Another thing that you're going to encounter as you study in Domain 1 is the importance of human rights. Hello and welcome back to Privacy Professional Training. My name is Fumi Owolabi. Today's video, we're going to be looking at the Domain 1 for the CIPPE exam. Let's talk a little bit about background. The CIPPE exam stands for the Certified Information Privacy Professional for Europe. It is a 90-question exam. You have 2.5 hours to answer the questions. We're going to be looking at the 5 domains. So for anybody that's brand new to privacy certifications, if this is your first privacy certification, then I think it'd be very important, and I've talked about this in other videos, to take a look at the body of knowledge. They do change frequently. I took this exam a couple of years ago. I have other videos on the exact year, but I have done a number of privacy certifications. This video, we're going to talk about Domain 1. We're going to talk about the history of the GDPR, which, if you're brand new to data protection, the GDPR is an incredibly important data protection legislation, and it influences organizations globally based on its applicability, its scope. We're going to go through all of that. I want to talk a little bit about history, and I also want to talk about some of the themes that you may encounter as you study in Domain 1. Now, I've talked all about strategy and how I study for my own privacy exams. I have several videos on this channel. You can check them out. But today we're going to be looking at the Domain 1 history and origins of privacy legislation in the European Union. Without further ado, the first thing we're going to be looking at is Convention 108. Convention 108 is incredibly important because it was the first binding treaty that focused on data protection. Now, I think the value of looking at the history in Convention 108 is that you're going to see themes that don't just exclusively operate in the European Union, but if you're a privacy pro and you plan to do something called privacy cert stacking, and I've done a whole video about privacy cert stacking, you're going to see themes in the European Union that are going to be recurring in other geographies and other privacy certifications that you take. But for the purposes of Domain 1, I want to talk about how the importance of this first binding treaty that focuses on data protection. Another thing that you're going to encounter as you study in Domain 1 is the importance of human rights. So there's certain discussions in this domain that are going to look at things like the right to not being intruded upon. Let's talk a bit about the OECD guidelines. Now, you're going to encounter the OECD guidelines in many different privacy certifications, but it does appear as a theme that is discussed in Domain 1 for the CIPP exam. And so the OECD guidelines discusses different foundational principles that guide processing of personal data and what data protection means, some themes that you're going to see that appear in legislation. So it puts down some guidelines. Again, guidelines are not legislation, they're not binding. But some of the themes that you'll see in the OECD guidelines is accountability, being accountable for certain actions that organizations are taking. You're going to see transparency. We see transparency come up in things like the creation of privacy notices, whether it's a privacy notice that appears on a website or a privacy notice that is distributed to employees. Those are themes that are discussed in the OECD guidelines. In addition to this, one of the guidelines discusses purpose limitation. If we're going to be collecting data, and I reference purpose limitation in lots of my videos because it is a foundational principle in data protection that guides a lot of the activities that businesses conduct. When we're looking at data protection, we're looking at obligations that organizations have based on what statute requires. And if an organization is going to conduct an activity on personal data, then there needs to be a purpose and it needs to be limited to that purpose. So I did a video a couple of weeks ago and I also discussed purpose limitation there because if you are going to privacy cert stack, you're going to see purpose limitation effectively come up in any privacy certification that you do, irrespective of who the governing body is that offers the test. So let's talk a little bit more in depth about purpose limitation. I think it's very valuable because we know that there is a recurring theme of human rights in the European Union. And as you continue studying throughout the different domains for the CIPP, you're going to see the restrictions that are placed on how processing can be conducted in different industries like marketing. So let's talk just about the theme, purpose limitation. So for example, if you're going to be conducting email marketing as an organization, if you tell consumers in your privacy notice, I will use your data to distribute email communications. You cannot then go ahead and use that data and sell it to a third-party broker for remuneration because you've not presented notice, and that was not the original purpose for collecting the data. The original purpose was that email communications. And in addition to that, this purpose limitation principle comes up when we think about things like not just repurposing, but also not collecting more data than is required for the purpose. If the purpose here is email communications, we're not going to be collecting date of birth because it does not suit the purpose for which we collected the information. So we should always have a purpose. And as we continue through the domains, you're going to see things like different privacy documentation that is actually required under statute. For example, the ROPA. We're not going to get into too much detail in this video. We're just going to look at some of these foundational principles. Let's talk about the Data Protection Directive of 1995. So this also is discussed in Domain 1. Now, the value of looking at this directive is it is the predecessor to the GDPR, which is the General Data Protection Regulation. And we're going to talk far more in depth in other domains about this legislation because it is instrumental and it does have influences on organizations that are not European Union based, but provide products and services, and we'll get into all of that later. But I want to talk about the predecessor because you are going to encounter, as you continue with your studies, you're going to encounter discussion on the failings of the preliminary directive from 1995. And when you are collecting your resources to either practice questions on this, you are going to see some of the failings for the directive. For example, the complications that organizations had when it came to understanding what their obligations were under this statute. The original goal for the directive was to create harmonization, but actually there were complexities within the directive that made harmonization incredibly difficult for organizations. And we can see the timeline too, that the original directive came out in 1995, and then subsequent to that, about almost a little bit over a decade later, we then get the GDPR. So understanding the origins for European Union data protection legislation is also going to help when we come to other different types of themes, and also understanding restrictions that the GDPR places on organizations doing business outside of the European Union. Domain 1 also talks about European Union institutions. I think it's going to be very important to have a basic foundational understanding of how each institution works. So let's take, for example, the European Commission. The European Commission is the entity that proposes the legislation. The European Parliament and the Council of the European Union adopt that legislation. The European Council provides political direction. We've got the Court. The Court of Justice of the European Union interprets European Union law, and that includes the GDPR. And then we also have the European Court of Human Rights that enforces the European Convention of Human Rights. So we have lots of different institutions that is separate to other geographies. If this is your first privacy exam or you're based in the European Union, you may be very familiar with all of these entities already, but for other privacy exam takers who are not European based, it's going to be very important to understand the adoption, the relationship between each of these institutions on more than just that preliminary level that I've just dictated right now. So institutions, those foundational principles that you're going to see are influential on the other domains, and then the influence of human rights and those foundational principles too. So this was just a preliminary introduction to some of the themes that you're going to see in the CIPP exam for Domain 1. The takeaway that I would have here is to make sure that you are memorizing concepts. You're going to encounter many unique concepts to the European Union that may not necessarily be found in the United States. And I've done several videos about the CIPP US exam. Privacy in the United States is fragmented. It's far more comprehensive in Europe, and it's going to be incredibly important to understand the workings of the different institutions that play a part in, one, the creation of privacy legislation, and two, its enforcement. So I really hope you enjoyed this video. If you have comments or questions about Domain 1, leave them below, and I will see you in another video.